Alright, so this is just We the People News. One more time at it. I'm not an attorney, not giving legal advice. Anything I say or do is just hearsay. Okay? Do not take it as legal advice whatsoever. I don't know. Alright? I never just look straight forward. I always look around to be able to protect myself by any means necessary, which follows up that I use the Second Amendment, arm myself with knowledge. Okay? This case is going to be interesting, as you see in the corner there. This is from the courtroom files. So, you see the red mark. If you want to see the whole thing, jump over there. Now, whatever he did, whatever I say about him, he is one of the best judges in Texas that I'm aware of. Okay? And, but this one I think is a little bit wrong, and I'm going to explain why. Okay? Let's go.
Judge Roach, Richard Ramos again. I don't know if you've taken a look at the cases that the state provided. They're very distinguishable, both of them. On one, the Prego case, someone actually sees the driver driving at some point, and then
I've read about 17 different cases.
right, and then the second one that the state has provided, the driver self-admits that they were driving at some point, and in both cases they have the seatbelt on, and there's other evidence of driving and operation, which is distinguishable. In this case, there's no facts that he had a seatbelt on, or he was seen by anyone driving, or he ever admits to driving. So their reliance on those cases are unfounded because it doesn't fit this fact pattern that we have before us today.
So, Judge, the first case that I'll refer you to is Prego versus State, which in that case,
Do you need email it to me, Mike?
I can send you an email right now, Judge.
That's the one the person is seen at some point.
Can I make my argument, Counselor?
No, I thought you were emailing, yes.
I am, but let me at least make mine.
I wanted to give him a synopsis of the case.
Let me make my synopsis, and then I promise you I'll let you respond.
I was in that reading. I must have read like 17 cases. God. I don't think that there was any case that supported your position. You know, I must have gone through at least 17 different
Well, they have to prove it's a totality of circumstances. Just behind the wheel is not sufficient. They have to provide. Okay.
So let's go to Kenneth versus State, Judge. I sent you an email. Did you receive it? Okay. So in that case.
Whoopsie.
Sun chips? Forgot how good those are.
Okay, so now there's been case laws saying this and this and this, but it's due to people's confession, witnesses, and all that kind of stuff that they once was driving. Okay, so there is a standard in that particular category of the prosecutor. However, due to this other guy, there was no witness or any standards of him been driving. Okay? My internet's been slow here lately for some reason.
Just an ordinary day.
I'm reading just word for word from the case. Courts interpret, quote, operation of a motor vehicle very broadly, and they cite Prego versus State, which is a...
Right there. The courts interpret it very broadly. Okay? I call it absolute, vague, and ambiguous, absolutely, for the state's benefit, never the people's. Okay? Anything is supposed to be interpreted where the average man and woman can understand. And this is one of the issues I have in this said case.
Appellate case, they cite Smith versus State, which is an appellate case, and they say, quote, while driving does not involve operation does not necessarily involve driving. So we have to prove operation of a motor vehicle. Operation does not necessarily mean driving. It states any action that is more than mere preparation towards operating a motor vehicle falls under the definition of operating. So in this case, we have
Does the fact that you turned the keys onto the car,
is enough, Judge.
That's his opinion. There's no case law that
That's
says
what the
that.
case law literally
You're saying
states.
mere
word
preparation
for
like
word.
conspiracy, right?
Yes.
The law
Or
of conspiracy
law.
is, it has to be more, like.
So what did he do other than start the vehicle? There's nothing more than there's nothing more than mere preparation. It
And
was a
that's
hot day, and the Prego case, people see him, they have the seatbelt on, which is more than mere preparation. They don't show the seatbelt on. In the other case, the Houston case, it self-admits that they were driving. In this case,
Yeah, I mean, that's right, we're not gonna, if there's a self-admission, that's.
right, and those
now
are what they relied on. The two cases, on the second case that he's quoting, or he's showed you on the site, that defendant self-admitted, and there was also other evidence
Have you
beyond mere preparation.
You found any case law to support the position, though?
Well, what position? It's their burden that there was more than mere preparation.
No, but I've asked you to see if you, because I went back and I literally read through 20 cases.
Yes.
And I can't find any case that supports the proposition that that's not operating.
Well,
And there we lie the problem. Okay, so his case is pretty much unique. Okay, it's outside the square. And the issue we have, since there's not case law on this, and I don't even believe in case law, it makes judges lazy and they don't have to think. They keep on going back with case law. Well, there may be 5 different cases. It's the same as mine. But them 5 different cases does not apply to me because mine's a separate case. Each and every case should be judged in the 4 corners in my case, not previous cases, because there's always something different, and judges don't even have to think nowadays. They depend on the other judges in the past to do all the thinking. And but that being said, y'all, that right there is burden on prosecutor. But regardless how much I like him, okay, I am led to believe and do believe he was wrong on this one, because even with this 10th Amendment, all right, if there's no law, and I'm going to go with law case in this case, all right, it is common practice, supposed to be, allegedly, by the judges, that they must go on the people's behalf, not on government's behalf, all right? And this is one of the prime examples that the judge should have went on the people's behalf in this said case, because nobody found case law that matched his particular standing, okay? And this is what this attorney is actually talking about right here. And the burden of proof is on the prosecutor, but they keep on wanting to get information from him. Well, that's not his job. It's to defend what evidence the prosecutor has. I know, y'all, there's a reason why they call arguments, going back and forth and all that. But, again, he is telling him over here to prove his client's innocent now, when he knows all the case laws and all that applied to some form of self-evident of driving. In this said case, he was asleep in his car on private property, and of course he was drunk and all that, but he could have slept there and slept it off. If it was summertime, AC was on, nice and comfortable. If it's wintertime, heater on, nice and comfortable. There was no seat belt or anything else leading to him driving while he had been drinking. Okay? So he may already knew with basically a commercial license, he drove a a commercial vehicle. Okay. He did not want that on his record. So he may have partied too much, realized he was drunk, went in the car, instead of driving, went to sleep it off instead of going home. Okay? So that right there is enough reasonable doubt that he was intent of going home and driving under the influence. Okay? The key word is we got to remind ourselves is the intent part. Prove the intent that he was not, if he was going to drive home drunk.
What they have to show is more than mere preparation. Having your vehicle on by itself is not beyond mere preparation. That is just mere preparation. They have to show either had a seatbelt on, or the car was in neutral, or something beyond just in the car getting AC on a hot day. I mean,
If you can,
And Judge, there's no, you're right.
and you know,
Right.
I'll certainly look.
I mean, that's what everyone, our legislatures tell us. If you feel like you should just stop and pull over, and that's what he did. And then someone comes at a later
Care
time.
about your.
No, I'm not. Because if you stop, turn off your car, and then you get hot because you're in a hot vehicle, turn it on. That's not operation. That is not beyond mere preparation.
Where are you getting that from? How are you saying that's?
It's the same principle if I was traveling, right? I pulled over into a rest area, took a nap because I was too sleepy to drive. At that particular time, I'm not operating a vehicle. I'm sleeping. That's the reason why they call it sleep. It's to rest. And he may, allegedly, could be sleeping to sober up and proceed forward in his movements. But that rest area, that's just like saying an officer can go in a rest area, in any rest area, and say, hey, you've been drinking because you're asleep. Even though I was traveling and I just took a nap. Just saying.
Operation. What is your citation for that?
You just stated in your case law that you have to prove more than mere preparation.
Okay.
My statement is all you have shown is mere preparation. That's it.
But
You have gone beyond mere
but to be
preparation.
clear, you don't have any legal basis for your opinion.
Yes, your opinion is right there when you said you have to. It's a totality of circumstances, and you have to show more than mere preparation.
And I think the fact that
There is no case law that says that.
find me something.
Well,
else.
that case says it. That case says just turning on your vehicle, you have to show more than mere preparation.
That's not what it says. It doesn't
You
say
read
just turning on your vehicle is not enough. That's not what it says.
Is that Prego?
This is Kennett versus State.
And then that case is also
I'm
distinguishable.
gonna read it exactly what I read to you just a couple of minutes ago, Judge. Courts interpret operating a motor vehicle very broadly, and they cite multiple cases. While driving does not involve operation, operation does not necessarily involve driving, stating that any action that is more than mere preparation towards operating a vehicle falls under the definition of operating. So, any action that is more than mere preparation towards operating a vehicle. That does not state that doing this with a key and turning on the car is not more than mere preparation. Our position is that that is more than mere preparation. You've put the key in your car. You've activated your vehicle. That is more than mere preparation. You're attempting to operate the motor vehicle. You don't need to be seen driving the vehicle to satisfy operation under this case.
I want to be clear. I'm not saying it has to be seen, but they're stating exactly conversely what I'm saying. You're asking me to show you where just putting on the key is not operation. Well, I'm asking for them to prove just putting on the key is mere preparation, because they're stating a case where the defendant admitted to driving. Okay, in that case, and that is in the facts of the case, and that's what the court relied on. That in addition to this law, that he admitted to driving.
You're saying in Kenneth,
Yes, that
Admitted to
defendant
operation.
took the stand, admitted that at some point she operated the vehicle. In the Prego case, someone saw that person driving the vehicle. Then they saw him at a later time.
They admitted to driving at an earlier time.
Yes,
They didn't
yes,
admit to driving then.
yes, that's
Can you-
correct.
can you point to me to at least one case that shows me that where they have found it not to be operating?
No, but I'm also gonna state this to the court, can they show you one case where just having the key in the ignition is more than mere preparation? They haven't shown you that.
I went through 17 to 20 cases, Herman. I haven't found. I looked.
Either way, I bet. Either way, either way. So it's up to the court's discretion.
I didn't find anything to support the position.
Theirs or mine.
So let's do this. I'm gonna find it for now.
Okay.
Go back, do some research.
No, there isn't. I'm very clear on the law. They have to show more than mere preparation. And they haven't in this case.
So he does find probable cause, and this is where I think he's wrong, right? Because when he walked out there, he was asleep. His seatbelt was not on. He was not getting ready to drive anywhere. He just slept in his car seat and turned the air conditioner on in this case, so that way he could stay cool, and went to sleep the thing off, okay? Whether 2 hours later, 3 hours later, that's still irrelevant in this case. The intent was for him to be in that driver's seat to go to sleep. That was the intent. Okay? And I think that's what they should have done, is use the intent of sleeping. It wasn't preparation because he was sleeping. There was no preparation to go anywhere. There would be preparation if he went in there, got his seatbelt on, or start his car, maybe start putting it in gear or something like that, some form of movement for the officer, especially when it was on private property, right? But being, I don't know, y'all, this is me thinking outside the box, and I just came across this video a few minutes ago, and I thought this was an interesting one. So, this is Decent We the People News. You guys tell me what you guys think. Because remember, y'all, never just look straight forward. Always look around you to be able to protect yourself by any means necessary. And again, he was wanting case law, and he did not want to think for himself. Okay? And this guy right here had reasonable doubt, especially with the guy sleeping in the car. That's intent of sleeping, not operating or driving. Okay? Just saying. His intent 8 hours from now could be driving. It could be 5 hours from now. Right? How many hours was he supposed to be, the officer, how many hours was you going to sit here and sleep? You know? Just saying. These We the People News. Bye, y'all.